For the next few minutes, I'd like to discuss the estate planning model. The estate planning model is designed to provide a framework for thinking about the process of estate planning and establishing your specific objectives. The topics we'll be visiting about include the model itself, how we use that model to prepare for incapacity, how we use it to plan for death, and what our objectives are at the time of death. We'll talk briefly about property and property ownership, about probate and non-probate property, and then the procedure involving settling an estate. The estate planning model itself is pretty straightforward. We look at it in terms of transitions from the present time, where you are able to make your own decisions and manage your own affairs, to incapacity, where you may not be able to do that, then ultimately your death, and finally how you leave things for your survivors. When we look at planning for incapacity, the first question is, what is it? There is no bright line definition, but typically we look at not being able to make decisions for yourself and not able to communicate. The issues on incapacity come in two different flavors. The first is with respect to healthcare decisions, and there are several documents that we'll talk about later in terms of how you deal with healthcare and incapacity. There is also the property decisions, and again, a document we'll talk about later for managing that. In terms of planning for death, we start by looking at what are the legal objectives. Those are going to include establishing the authority for someone to act on your behalf after your death, collecting the assets that you own, paying the debts and expenses, and then distributing the balance. The main purpose of this, the main objective, is to protect the creditors. But there are personal objectives as well, and these relate to who makes decisions, who is in control, how the property is going to be used or distributed, how do you manage conflict within a family situation, how do we minimize taxes, and how do we simplify procedure. Note that here our interest is in protecting the family. Property is the stuff that we own. It includes things like bank accounts, your residence, vehicles, retirement plans, life insurance, annuities, investments, real estate, business interests, and a whole host of different miscellaneous types of assets. For each of these, we are concerned with how it is owned. Is it owned in your sole name, meaning that you have complete control over it? Is it owned as tenants in common, something that you and another person own together? Is it owned as joint tenancy with right of survivorship, another form of co-ownership where you own property with another person? Do you have just a beneficial interest in it? You may not own the underlying asset, but you receive the income from that property, let's say. Or is it owned in a trust? Once we've established the property that you own and how it is owned, we can then look at whether or not that property is probate property or non-probate property. Probate property includes property that you own in your sole name or you own as tenants in common. Non-probate property is property that you own as joint tenancy with right of survivorship, or an asset that you have a beneficiary designation upon, or an asset that you own in trust. The thing that I want you to remember is that your will only controls your probate property. It does not affect your non-probate property. On this next chart, you can see how we look at properties being effective at death. They are either a probate transfer or a non-probate transfer. And despite this stuff in the middle here, let me call your attention to the distinctions of the procedure. If we're looking at a probate transfer, we can have that property transferred by a distribution by affidavit, by a small estate administration, or a regular estate administration. And if we use primarily non-probate transfers, then we are in a position to use a procedure called probate without present administration. Our next step in the planning procedure is to compare how this will play out with probate property and non-probate property. As you can see from this table, there are 3 forms of probate administrations and 1 form of non-probate administration. The 3 probate forms, distribution by affidavit, small estate administration, regular estate administration, are used depending upon what the asset values are. And in general, what you will see is that particularly with the small estate and regular estate, you'll be incurring court costs, executor fees, and attorney fees. In addition, in those 2, you will also see that there is no privacy. There is an open file in the courthouse for anyone to come and take a look at. And so if you have assets more than $25,000, we often look at whether or not a non-probate procedure, probate without present administration, may be a reasonable way for you to shorten the time frame for the administration, reduce the overall costs, and maintain privacy in the process. We'll be discussing this in greater detail in the next movie.